All right, my people, welcome back. Lawyer finally reveals why Sunday Igboho is seeking 500 billion naira damages from Nigerian government. All right, my people, the news in details. Well, onto this, Aliyu added that the July 1st illegal invasion added to the huge loss given, the lives lost, and the value to the property vandalized. The lead counsel to Yoruba Nation activist Sunday Adeyemo, aka Sunday Igboho, Yomi Aliyu San, has explained why he requested 500 billion naira as compensation for his client. Speaking with Nation, Aliyu said his decision to ask for 500 billion naira exemplary and then aggravated damages for his client at an Oyo State High Court was to deter the Department of State Security DSS personnel from attacking citizens illegally. He had there is a case that says when something is rampant and you want to stop it, you must ask for aggravated and exemplary damages. DSS personnel have been raiding citizens' houses illegally. They won't stop until this kind of damage is awarded against them. It is to act as a deterrent. Asked further now how he chose the humongous amount, he said his client had already suffered huge losses by the raising of his house earlier raised. He said the house was worth 300 million naira. Aliyu added that the July 1st illegal invasion added to the huge loss given, the lives lost and the value to the property vandalized. It is to deter them from further illegal raids and invasions, he stressed. Igboho, through his lawyer Aliyu, filed a suit challenging the invasion of his house in Ibadan on July 1st by operatives of the DSS, also known as the State Security Services SSS or Secret Police. Igboho sought an order of the court to declare the invasion of his residence by DSS operatives as illegal and an infringement on his fundamental human rights. The three respondents are the Attorney General of the Federation and the Minister of Justice Abubakar Malami San as the first respondent, SSS as the second respondent, and the Director of SSS in Oyo State as the third respondent. Last Friday, the court granted a relief sought by Igboho and ordered the Nigerian government to pay him 20 billion naira. Citing several judgments by the Supreme and Appeal Court in respect of the ability of the State High Court to hear such cases, Justice Ladiran Akintola said the invasion of the house of the applicant violated his fundamental human rights as stipulated in the Constitution of the Federal Republic of Nigeria 1999 as amended. Unfortunately, this court is not a Father Christmas and cannot award the sum of 500 billion naira as requested by the applicant, but the court restrained the respondent from arresting or harassing the applicant. He has right to his free movement as contained in Section 35.1ab of the 1999 Constitution as amended. While given the judgment, Justice Akintola held that the DSS did not deny the invasion, pointing out that the revelation that the female officer that led the invading team loudly instructed the personnel to shoot Igboho dead was a serious threat to his life. He added that the DSS obviously went after Igboho because of his agitation for self-determination. He said the invasion is based on arbitrary aggression and prejudice in the absence of any evidence that Nigeria was in a state of war. It is therefore condemnable, reprehensible, and crude, he said. Akintola said the DSS did not deny the invasion, stressing that it only justified it in its argument. The invasion of July 1st amounts to a violation of the applicant's right to personal liberty as guaranteed by the Constitution. There was no order of the court against the applicant for which he has been found guilty to justify the arrest, he said. He pointed out that the invasion was a move to stop Igboho from continuing with his rallies for the Yoruba nation in southwest Nigeria, whereas he enjoined the constitutional right to do so. The action of the second and third respondent against the applicant amounts to a violation of his right to agitate for self-determination as enshrined in the Constitution, he said. On the claims by counsel for AGF and DSS Abubakar Abdullahi and T.A. Nuruddin that the case did not qualify under the Fundamental Human Rights Enforcement Procedure and that Igboho had not provided sufficient evidence to demonstrate that his rights were violated, the judge said Igboho had demonstrated with a preponderance of evidence that his rights were violated. He stressed that the alleged embargo placed on his bank account were one of such violations. All right, my people, well, a lot of things are actually being said on to this one. Well, and then after considering all things, Justice Akintola said he found merit in the application and described the DSS Act as reckless and despicable. He said he did not believe that Igboho'S aides exchanged gunfire with the DSS personnel as claimed. All issues are hereby resolved in favor of the applicant. This court accordingly grant all the reliefs sought, save damages, are hereby awarded 20 billion naira as exemplary and then aggravated damages because of the illegal invasion of the applicant's house, is said. All right, my people, and then this is what it is. Well, I think this is a very great news. Well, a lot of people have seen it that, oh, this is a very good one. If the country can take it up from here, then this set of people will not be invading people's house illegally. By the time they are being given a huge sum of amount as penalty, then they will learn their lessons. Well, I think the justice had done a great thing, a great deal onto this one. Well, my people, what more can we say? Meanwhile, let me have your take on this, and remember to subscribe for more updates if you have not subscribed to this channel. Thanks always.